They were killed legally. Their names were posted in public. Anyone could hunt them down, and the state would pay the killer. This was not mob violence or civil war chaos. It was a system formal, written, enforced where murder became an administrative task, and refusing to participate could put your own name on the list next. What happened was called justice. The records call it lawful. History remembers it as proscriptions, and it permanently rewired how political power worked. The victims were not criminals in the usual sense. Many were senators, magistrates, wealthy landowners, retired soldiers, businessmen, and relatives of political enemies. Their common trait was vulnerability. They had influence, money, or past affiliations that could be reframed as treason. Some were killed not for what they had done, but for what they owned. Others because someone else wanted their house. Roman sources agree on one fact. Once a name appeared on the list, there was no appeal, no trial, no investigation. Death was the sentence, confiscation the reward, silence the aftermath. The people targeted had lived ordinary elite Roman lives before the lists. They attended the Senate, managed estates, maintained patron-client networks. Many had survived earlier political violence and believed status or past service would protect them. That assumption turned out to be fatal. Some victims went into hiding immediately, relying on friends, freedmen, or slaves. Others misjudged the danger and stayed put, believing their name would never appear. Several were betrayed by those closest to them. Roman historians record cases where slaves killed masters to claim rewards, sons turned in fathers, and neighbors reported neighbors to settle debts. The rules were explicit. Anyone who killed a proscribed person received part of the confiscated property. Anyone who sheltered or raided a proscribed person faced death. The victim's descendants were barred from holding public office. This was not temporary punishment, it was generational erasure. The timeline unfolded with speed and deliberateness. Lists were posted in public spaces, removed, then replaced with new ones. The delay between posting and killing could be hours or days. That uncertainty amplified fear. People gathered around the boards daily, scanning for names. Absence one day meant nothing. A name could appear tomorrow. One of the most disturbing features was retroactivity. Individuals who had already been killed could be added afterward, legitimizing murders that had technically been illegal the time they occurred. Violence followed paperwork, and paperwork followed violence. The machinery behind the killings was decentralized by design. There was no single execution force. Enforcement was outsourced to citizens, soldiers, and opportunists. This allowed the state to maintain plausible distance while ensuring efficiency. Killers did not need warrants. The list itself was the warrant. Investigative safeguards did not exist. There was no verification process to confirm identity beyond name recognition. This led to documented cases of mistaken identity, men with the same name killed, only for the error to be discovered later, after property had already been seized. There was also no fixed endpoint. Proscriptions were announced as limited, then expanded. Initial assurances that only a small number would be targeted collapsed almost immediately. Ancient accounts record shock even among supporters when the scale became clear. One Roman writer reports that names were added not because of political threat, but because someone requested it. Another records that the lists grew whenever the treasury needed replenishment. Confiscation was not a side effect, it was central. There was also no fixed endpoint. Proscriptions were announced as limited, then expanded. Initial assurances that only a small number would be targeted collapsed almost immediately. Ancient accounts record shock even among supporters when the scale became clear. One Roman writer reports that names were added not because of political threat, but because someone requested it. Another records that the lists grew whenever the treasury needed replenishment. Confiscation was not a side effect, it was central. The investigation, such as it was, existed only on paper. Official records tracked confiscated estates, redistributed land, and financial gains. There is no evidence of systematic review of accusations. Guilt was assumed by inclusion. Inclusion was controlled by those in power. What should have happened, by Roman legal tradition, was prosecution before a court, evidence presented, and a verdict rendered. Rome had a long, if imperfect, tradition of legal process. The proscriptions bypassed all of it. They were justified as emergency measures, but they lasted long enough to become policy. The suspects, in the modern sense, were not hidden. The system itself was the suspect, but individuals still mattered. Lists did not write themselves. Decisions were made about who was dangerous, who was expendable, and who was profitable. Some names clearly reflected political, targeting leaders of the opposing faction, military commanders with independent loyalty, outspoken senators. Others did not fit. Wealthy men with no recent political activity appeared. Their inclusion is harder to explain without acknowledging personal vendettas or financial motives. Roman sources conflict on who controlled additions to the list. Some suggest central approval. Others describe a more chaotic process, where powerful allies could request names added. The lack of transparency ensured deniability. Public reaction was complex. There was fear, but also participation. Rewards turned neighbors into enforcers. Silence became survival. The Senate, reduced in number, formally endorsed measures it could not oppose. Institutions continued functioning, giving the appearance of order. Over time, the killings slowed, not because of moral reckoning, but because the most lucrative targets were already dead. Land had been redistributed. Political opposition had been decimated. The terror had done its work, but the damage did not end when the list stopped. The precedent remained. Future leaders understood that legality could be manufactured, that killing could be normalized through procedure. That fear was more efficient than persuasion. Several unresolved questions remain. How many people were actually killed? Ancient estimates vary widely, and records are incomplete. How many deaths were personal vendettas disguised as politics? How many families were destroyed without ever being named in surviving texts? There is also the question of consent. How much of society supported this system, and how much complied out of fear? The sources are written mostly by elites who survived. The voices of the erased are absent. The most unsettling contradiction is that this system was later praised by some as restoring order. Stability was achieved, but only after law was inverted into a weapon. The state survived by teaching its citizens that legality did not equal justice. The proscriptions were not an aberration. They were a demonstration. They showed what happens when institutions stop asking whether they should act and focus only on whether they can. Rome would never fully recover from this lesson. The machinery built to eliminate enemies would be reused, refined, and inherited. Once murder becomes administrative, it does not easily return to being a crime. What remains is a warning embedded in history's paperwork. The most dangerous violence is not chaotic. It is organized, documented, and rewarded.